All right. Good morning. Welcome to our second roundtable on trade through prohibitions. My name is Jamie Selway. I'm the director of the SEC's Division of Trading and Markets. We're going to kick off shortly with a full day of discussion and debate. Start with our chairman, Chairman Atkins. Come up and get some remarks.
Well, good morning, everybody, and is this working? Maybe not, but anyway, thank you, Jamie, for hosting this event and getting us started here. So I'm pleased to join everyone today and welcoming you to today's roundtable. I should also like to acknowledge and thank the University of Austin. This is my first time here at the new university, heard lots about it, and welcoming you to today's roundtable. And also to obviously for their setup here and accommodating us for our roundtable. And also really thank our esteemed panelists for contributing their perspectives, and of course to our audience, whether here on campus or by live stream, for taking part in this very important discussion. Finally, before I share a few reflections, I must add that the views I expressed this morning are my own as chairman and do not necessarily reflect those of the SEC as an institution or my fellow commissioners. As I noted in our September roundtable, the SEC adopted regulation NMS at a time of profound transformation. Electronic trading systems were continuing to In 2005, the Commission decided to impose prescriptive rules and dictate very specific processes to address what it perceived as ills, even though these new trends and technologies were still evolving. Worse, the staff came out with repeated rounds of FAQs to try to ameliorate the challenges that their problematic rules engendered. While I fully supported then, as I do now, the worthy goal of enhancing market efficiency, then Commissioner Cynthia Glassman and I objected to Reg NMS's adoption because we believed that the rigidity of its regime, especially Rule 611, would hinder rather than enhance the long-term growth of our markets. 2 decades have given us the benefit of perspective, and the verdict is clear. Reg NMS, built on flawed foundations, has invited gamesmanship and contributed to the fragmentation of our markets, the dispersal of liquidity, and diminished transparency. The very outcomes that Cindy and I feared have come to pass. Our warnings are now lessons, and Reg NMS, Rule 611's trade-through prohibitions in particular commend a fresh look so that we can continue to strengthen our securities markets. Indeed, we must summon the courage to acknowledge when well-intended policies have produced unintended consequences. So to this end, our first roundtable engaged an array of industry participants, academics, and regulators back in Washington for a very fruitful initial discussion. Their perspectives, along with the thoughtful comment letters that we have since received, underscore a broad consensus. Revisiting Rule 611 is a worthwhile and overdue endeavor. While views may vary on the scope of potential changes, a significant number of panelists and commentators believed that the rule should be modified or rescinded entirely. In September, we also heard several potential paths forward, including volume thresholds for protected quotes, block exceptions, rescinding the locked and cross-market prohibition, adjustments to access fee caps, and revisions to the market data revenue allocation formula. Each of these proposals merits serious consideration. As I cautioned 2 decades ago, we must take a careful, deliberative approach to any changes, lest we make the mistakes that brought us here. So today, we take a necessary step in that process. Of course, we will continue our discussion of trade-through prohibitions, but we will also delve more deeply into how Rule 611 intersects with other parts of Reg NMS rules and our market structure more broadly. Specifically, our first panel will focus on Rule 610 and its requirements relating to fair access, access fees, and locked and crossed markets. Our second group of panelists will then discuss Rule 600, including the defined terms intertwined with the trade-through rule, the effects on the NBBO, as well as the incentives associated with the market data formula revenue allocation from the consolidated market data plans. And then finally, our third panel will examine potential enhanced best execution guidance if the Commission modifies or rescinds the trade-through prohibitions of Rule 611. So today's roundtable will help ensure that we do not saddle a future commission or the next generation of investors and market participants with the same set of challenges that we left for ourselves 2 decades ago. We owe it to them to be thoughtful, to be rigorous, and to be reflective. So I want to thank our panelists and moderators once more for being here. I should also like to encourage members of the public to continue sharing your perspectives through our online comment file. As we undertake this reassessment of Reg NMS, your insights are indispensable. So I look forward to today's discussions and to the takeaways that surely will emerge from them. Thank you all for being here and for your continued engagement with the critical work before us. Thank you very much.
Thank you very much, Mr. Chairman. Commissioner Peirce.
Morning, and thank you, Jamie. It's wonderful to be here today. I have to say my views are my own as a commissioner, not necessarily those of the SEC or my fellow commissioners. I want to begin by expressing my sincere thanks to all the panelists and to the University of Austin for hosting us in this beautiful venue, and to the Commission staff, especially from the Division of Trading and Markets and the Office of Public Affairs, who pulled together this roundtable in a very short amount of time. I also want to welcome any students in attendance. Your presence adds a valuable perspective to our conversation and may even inspire some of you to dip your toes into the enticing waters of equity market structure. One important regulatory determinant of market structure in the United States is the Order Protection Rule, also known as the Trade-Through Rule, also known as Rule 611. And if we were ranking whether or not to revisit Rule 611 on a scale of 1 to 10, with 10 being definitely revisit the rule, my gut gives me the middle schoolers' go-to answer, 6, 7. But a 6 or 7 on redoing 611 really misses some context. The necessary context consists of several factors. First, the U.S. equity markets are unmatched in depth and liquidity, which raises the stakes of any reform. Second, as many of the September 18 roundtables panelists noted, the distinctiveness of our market structure means that lessons from other jurisdictions may not always be instructive for us, particularly in areas like best execution and volume thresholds. Third, Rule 611 is intertwined with many other rules, and it's a complex nest in which equity markets live. So revisiting Rule 611 requires rethinking those other rules too. That message came through loud and clear at the September roundtable. While that roundtable featured robust debate over whether Rule 611 should be repealed, retained, or revised, it also reflected broad agreement that any changes to Rule 611 must be considered alongside related NMS rules, NMS plans, and FINRA regulations. Today, we'll talk about potential changes to access fee caps, the prohibition on locked and crossed markets, the fair access rule, the SIP revenue allocation model, FINRA's best execution rule, and more. Fourth, how we implement any changes, including how we sequence those changes, will matter. Given the expertise our panelists bring, I anticipate that this roundtable will provide the context necessary to boost my interest in reconsidering Rule 611 all the way up from a 6 or 7 to a 10. I've been a skeptic of Rule 611 since its inception 20 years ago. Dictating how market participants execute trades has never seemed like an exercise for which the SEC is particularly well suited. People operating in free and transparent markets are very good at figuring out how and where to execute trades or finding professionals to help them do so. Rule 611 rests for authority on Section 11A, a 1975 addition to the Securities Exchange Act, which directed the SEC to facilitate the establishment of a national market system, a function I don't think that the SEC, again, is particularly well suited to perform. That mandate really is a relic of a time of active government interference in and distrust of markets. Rather than adopting Rule 611 30 years after Congress gave us the authority, the SEC could have deferred to the technology that was eating away at market monopolies and facilitating cross-market arbitrage. Even those of you who disagree with me on this point may agree with me that Rule 611 has by now completed its work and may be causing more mischief than good. As emphasized in the previous roundtable, this moment presents a rare opportunity to strengthen our markets. While opinions differ on how well our current market structure serves investors, one trend is undeniable. Off-exchange trading volumes are rising, yet new exchanges, many of which replicate existing ones, continue to proliferate. This dynamic points to misaligned incentives and suggests the need for reform. I'm anticipating an organic conversation that requires little prompting, but I have a few prompts just in case. Given that some people view Rule 611 as a best execution backstop, if we eliminate it, how can we craft best execution amendments or guidance to offer clarity without being overly prescriptive? Are there any best execution clarifications that are needed now, independent of any changes to Rule 611? What is the optimal SIP revenue allocation between quoting and trading activity that will curb unnecessary exchange proliferation without foreclosing innovative new entrants in the exchange space? Is readjusting this allocation an interim step on the way to repealing Rule 611? What SEC and FINRA rules would need to be amended if Rule 611 were to be repealed? In the event that we propose changes to Rule 611, how should changes to these other NMS rules, plans, and FINRA rules be sequenced? Which changes must occur concurrently, which can follow, and which should precede any changes to Rule 611? As the SEC works with market participants experimenting with tokenization, can we draw any lessons that might be relevant to revisiting Rule 611? Thank you, and I look forward to the discussion.
Commissioner Peirce. Commissioner Crenshaw will provide remarks by video.
Good morning, everyone. Thank you for attending the second roundtable related to Rule 611, or the Order Protection Rule. As I understand from the agenda, today's roundtable will examine the potential impact of modifying or rescinding the mainstay of the Order Protection Rule, its trade-through prohibitions, on other associated rules and regulatory requirements. As a starting point, let's not assume that doing away with the Order Protection Rule is a magic bullet that will solve increasing complexity and fragmentation in the markets. As we all know, market structure is complicated, and reaching appropriate policy decisions in such a complex area requires understanding the relevant facts and the intricate ways in which the markets work, as well as balancing competing policy objectives. In sum, it's important to establish what is causing a problem in order to address it effectively. The Order Protection Rule is not a new source of controversy. When the suite of rules constituting Regulation NMS was adopted in 2005, the Order Protection Rule was the most controversial and attracted the most public comment and attention. Nevertheless, there was broad support in the record for the rule, and support for an intermarket price protection rule began long before, with the adoption by Congress in 1975 of the national market system itself. Both the House and the Senate committees responsible for drafting Section 11A of the Exchange Act specifically considered and endorsed the Commission's authority to adopt a price protection rule to achieve the statutory objectives of the national market system. The order protection rule and its emphasis on the principle of best price drew its support from commenters based on two fundamental rationales. First, maintaining investor confidence is essential to well-functioning equity markets. And increasing assurance that orders will be filled at the best prices will give investors, particularly retail investors, greater confidence that they will be treated fairly when they participate in the equity markets. Second, protection of the best displayed and accessible prices will promote deep and stable markets that minimize investor transaction costs. And minimizing these costs improve the long-term financial well-being of millions of investors and reduces the cost of capital for listed companies. I think it's important that we keep sight of these investor protection principles as we consider potential modifications to Rule 611 and related regulatory requirements. For example, how would such modifications impact execution quality for investors? And which investors might be disproportionately impacted? As I've said before, without investor confidence, the markets cannot serve their purpose as a place for investors to grow their savings. I hope that today's roundtable will yield thoughtful remarks and a productive conversation. Thank you again for your willingness to participate and for sharing your expertise.
Well, thank you, Jamie, and thank you to the Division of Trading Markets for organizing this roundtable on equity market structure, more specifically Rule 611 of Regulation NMS. I've been at the SEC now for almost 20 years, and one of my observations during the time is that people are often much more open with us when we're meeting outside of the confines of Washington, D.C. So thank you very much for being here. But I also recognize that when we do one of these events outside of Washington, it takes a lot more effort. And I particularly want to express my gratitude towards the University of Austin for making this roundtable possible. Regulation NMS may have been well-intentioned, but its implementation has coincided with shrinking displayed size, a significant increase in the number of execution venues, and complex routing behavior that is often difficult to explain to investors. Thus, I commend Chairman Atkins for initiating this review of Rule 611 and inviting participants to help the SEC evaluate whether the regulation NMS framework is truly serving investors and our markets. By revisiting the trade-through regime, we have an opportunity to move to a less costly, more resilient, and more transparent market structure, which would make our financial markets even stronger. This is not an easy task. My predecessor, Commissioner Elad Roisman, likened our equity structure rules to the threads of a sweater, hopefully not an ugly Christmas sweater. But in any event, pull one thread, you inevitably stress others, and sometimes in unexpected ways. I hope that these roundtable sessions and the public comments that we receive in connection with them help identify many of these other threads in Regulation NMS that interconnect with Rule 611, so that we can assess the consequences that might result from potential regulatory changes. One discussion that I look forward to hearing today is on the topic of best execution. A broker's obligation to seek best execution of customer orders is one of the cornerstones of market integrity. As I noted when the Commission proposed new rules in this area 2 years ago, best execution is a concept that has been developed by court holdings and specific rules from self-regulatory organizations. But to what extent does our current best execution regime presuppose or rely on entities' fulfillment of Rule 611? Are there other considerations that should be required if this rule is altered? The Commission should have compelling evidence of need before adding layers on top of the best execution regime already imposed by FINRA. Do panelists think that such a need would arise if 611 were to change? And if so, why? Relatedly, are there further ways that the Commission could increase transparency so that investors, counterparties, and regulators can observe execution quality across venues and enhance private ordering in this area? Last year, in 2024, the Commission adopted rule changes to modernize the reports required by Rule 605 to reflect how trading occurs in microseconds across multiple venues. In what other areas would transparency be needed for market participants to have the tools to assess execution quality on their own? Once again, I appreciate the thoughtful approach taken by the Commission staff to consider the entire regulatory framework holistically. This taking presents an opportunity for a serious retrospective review of Regulation NMS and Rule 611. With the public's input, I hope that the Commission can tackle these hard problems with evidence-based proposals, which was so lacking in the last several years, so that our market structure regulations can most effectively serve investors, intermediaries, and issuers. So thank you very much.
Thank you, Commissioner Ueda. Thank you, Chairman Atkins, for your remarks and for your leadership on a policy issue that is central to equity market structure. Thank you, Commissioner Peirce, Commissioner Crenshaw, Commissioner Ueda, for your remarks. Commissioner Peirce, given those prompts, I think we can get you up to 11. Thank you to my dedicated division colleagues, including Ted Venuti, Larissa Kidding, David Liu, and Kevin Brennan for gathering us here today, and to John Croper, Kelly Riley, Peggy Sullivan, and David Demetrius, who will join me as moderators. Thank you to the University of Austin, a new institution successfully bringing two of our favorite forces, innovation and competition, to bear to disrupt the market for undergraduate education, for giving us access to your facilities for the event today. And most importantly, thank you to our panelists. Today's participants represent a wide variety of expert perspectives in equity markets, shaped by nearly 20 years of operational experience with Regulation NMS. We are confident that your contributions will meaningfully inform the Commission's next steps. Before proceeding further, please note that my remarks today are provided in my official capacity as the Commission's Director of the Division of Trading and Markets and do not necessarily reflect the views or the vision of the Commission, the Commissioners, or the members of the staff. This disclaimer also extends to any comments of my division colleagues who will join me to moderate today's panels. On November the 4th, the citizens of the great state of Texas approved a ballot initiative to make certain security transaction taxes unconstitutional. Now, to anyone whose professional life or private enthusiasms involves trading or markets, this was a welcome development. Our nation's laboratories of democracy are a potent force for progress. The free air of Texas inspires and invigorates and reminds us that markets work. Today's event continues a journey that the division began earlier this year. In July, we invited public comment on the trade-through prohibitions applicable to the equities and option markets. And in September, we hosted a roundtable to discuss the issues associated with such prohibitions. We heard informed points of view and received thoughtful feedback. Many participants voiced concern with the status quo and suggested a re-examination of the trade-through prohibitions applicable to NMS stocks contained in Rule 611 of Regulation NMS, commonly known as the trade-through rule. As many noted, the trade-through rule is intertwined with other rules and regulations that must be carefully considered should the Commission decide to rescind or modify the trade-through rule. At the time the trade-through rule was adopted, many, including Chairman Atkins, warned that its complexity would lead to negative unintended consequences. 20 years later, we acknowledge this complexity and we pay keen attention to such warnings. Accordingly, today's roundtable aims to eliminate the trade-through rule's entanglements and other requirements so that if the rule is removed or altered, our market structure is improved and not damaged. We expect another lively, thought-provoking discussion today. We've designed these panels to more deeply consider the ramifications of rescinding or modifying the trade-through rule. When the trade-through rule was proposed as part of Reg NMS, commenters emphasized the futility of protecting the best displayed prices against trade-through rules if these prices were not fairly and efficiently accessible. Rule 610 promotes fair and non-discriminatory access to quotations displayed in the national market system. As adopted, Rule 610 sets forth standards governing access to the quotations to NMS stocks with a stated goal of promoting access in three ways: enabling private linkages, limiting access fees, and restricting locking or crossing quotations. During the September roundtable and in comments received, contributors urged consideration of the contrapositive. Are all of the requirements included 610 necessary if the trade-through rule is to be rescinded or modified? Our first panel will tackle this question. Much of Reg NMS's substance is contained in its defined terms. Our second panel will drill down on the necessary changes, if any, that may need to be made to definitions contained in Rule 600 of the Trade Through Rule. Of particular importance is any effect on the National Best Bid and National Best Offer, our NBBO. A robust, transparent, reliable NBBO is essential in promoting fair, efficient, and liquid markets. And the U.S. capital markets are rightly known as the most liquid in the world. For this reason, decades of Commission oversight of consolidated market data have centered on ensuring that the NBBO remains ground zero for price discovery and a consistent baseline for best execution. The second panel will also consider the incentives associated with the current formula for market data revenue share allocation and how these incentives affect the marketplace. Finally, our third panel will consider potential enhancements to the best execution requirements, including whether additional guidance is necessary if changes to the Trade Through Rule and associated rules are made. During the September roundtable and through comments received, many highlighted the relationship between the Trade Through Rule and best execution, suggesting that the Trade Through Rule changes could raise questions about how a broker-dealer should handle and execute customer orders. The duty of best execution predates federal securities laws. Its origin lies in the common law agency obligations of undivided loyalty and reasonable care that an agent owes to its principal. These duties are not merely historical. They remain essential today because executing orders is a core function of a broker-dealer's. Upholding best execution is not an empty tradition. Best execution is an evergreen obligation at the core of a broker duty's relationship with its customer. Over the years, a number of considerations have been identified by the courts, the Commission, and FINRA as relevant to best execution. These include not only price, but also speed of execution, clearing costs, size of the order, and the cost and difficulty of executing in a particular market, among others. As then Commissioner Atkins and Commissioner Cynthia Glassman pointed out at the time of Reg NMS's adoption, the Trade Through Rule seemed to elevate price as the sole criteria for determining how and where orders will be executed, and believe that the Trade Through Rule restricted investor choice and ability to obtain best execution. Of course, FINRA's role in this area is also critical. A best execution rule was first introduced in 1968 by its predecessor, the NESD, laying the groundwork for what would become FINRA's current rule, approved in 2011. Built on decades of experience with the predecessor rule and guidance, this framework has helped shape how market participants fulfill their obligations. As we consider the evolving market structure and the potential for changes to the Trade Through Rule, we welcome a thorough examination of FINRA's best execution rule, its accompanying guidance, and any enhancements that could strengthen its ability to serve investors effectively. So again, many thanks to all participating in today's roundtable. We have our boots on and we're ready to ride. First panel panelists, please join me up on the podium. All right, is everybody situated? We got these mics on? Excellent. So joining me as moderators today are Deputy Director John Croper and Senior Special Counsel Kelly Riley. We're going to kick off with each panelist introducing themselves, their name, their firm, and a sentence or two on their role, and then we'll get into the questions. Dimitri.
Sure. Good morning. My name is Dmitry Volkin. I'm a Managing Director and Head of Electronic and Portfolio Trading at Bernstein Institutional Services. Bernstein is a joint venture between Societe Generale Group and Alliance Bernstein. My firm provides equity research and cash equity execution services to institutional clients globally. Having spent more than 20 years in electronic and equity space and the market structure space, I also had a distinct privilege of serving as a senior policy advisor to Trading and Markets, the division of Securities and Exchange Commission, first under Director Redfern, and then under Director Zhu. I appreciate the opportunity to speak on the panel, and I look forward to the discussion.
Good morning, everyone. First of all, thank you to Jamie, Chair Atkins, and the commissioners for hosting another roundtable. I think I've expressed before how important these are. And so congratulations for doing another one. Appreciate the opportunity to speak again. I am Mehmet Kanak. I am the Global Head of Equity Trading at T. Rowe Price. T. Rowe Price is a mutual fund company, essentially. And, you know, this is our standard disclaimer when I speak on these things. We generate no revenue, zero revenue from trading. I want to make sure everyone knows that. I'm not up here trying to protect a book of business because I have zero book of business when I trade. So the intent here is to make sure that markets are performing efficiently and that the outcomes that we receive, hopefully, are good outcomes because they directly go back to our individual investors, and those are retail individual investors. So again, my other disclaimer is that we represent retail, even though we are a large institutional company, but it is for their benefit that we're up here trying to improve market quality.
Hi, I'm John Ramsey, Chief Market Policy Officer of IEX, the Investors Exchange, and proudly served on the staff of the Trading and Markets in two different SEC administrations over time. IEX is a national securities exchange that uses technology and innovation to create superior execution performance and maximize transparency and efficiency in operating our markets. We have long promoted regulatory reform seeking to achieve the same objectives for all participants. And so I'm very appreciative of the opportunity to be here and look forward to the discussion.
Good morning. I'm Brad Redfern. I'm the founder and CEO of Panorama Financial Markets. First of all, thank you very much to Chair Atkins, Commissioner Peirce, Commissioner Ueda, Commissioner Crenshaw, and for having us here today. Again, I think roundtables are a fantastic way to solicit industry input. So it's great to see these discussions happening again. This is fantastic. Panorama Financial Markets represents a number of companies in traditional financial markets and digital assets. So broker dealers, asset managers, and some firms who are working on the tokenization space. And strategic, regulatory, operational advice. And here I'm also proud to be represented, not representing any of my clients today, but I am working with the Texas Stock Exchange, among others.
My name is Oliver Sung. I'm a Senior Vice President, Head of North American Cash Equity Markets for Cboe Global Markets. Cboe is a multi-asset global exchange company operating in the U.S., Canada, Europe, Australia at this point in time. Thank you.
I'm Kevin Terrell, Kevin Terrell, Head of Markets at NYC Group. NYC operates 5 equities exchanges, including the New York Stock Exchange and the newly launched NYC Texas. So we're very happy to be here in Austin. We also operate options exchanges, a trade reporting facility, and an ATS for over-the-counter securities. I think it's also, just relevant to mention that we're owned by Intercontinental Exchange Group, and ever since ICE proposed acquiring NYC back in 2012, ICE management has been very interested in developments in U.S. equity market structure and really looking to keep advancing U.S. equity market structure forward. So, with that, I'd like to thank Jamie and the staff and the commission for having me here today.
Well, thanks, everyone. Thanks for joining us today. I'm Kelly Riley. And so for this panel, we're going to be talking about what the focus will be on Rule 610 and whether it should be, changed to the extent that Rule 611 is rescinded or modified. So as adopted in 2005, 610 addresses 3 subjects. It addresses the means of access to quotations, the fees for access to protected quotes, and the best bids and offers in the national market system, and locking cross markets. So let's start our discussion on the access fee caps. Rule 610C prohibits trading centers from charging fees for access that exceed 30 mils to access protected quotes and other best bids and offers. The Commission just amended the access fee caps to reduce them to 10 mils, and that change will be implemented in November of 2026. But for purposes of this discussion today, let's think about 2 potential scenarios. one where the 611 is modified and one where 611 is rescinded. So maybe if we can start the conversation with the scenario of where 611 is rescinded. So if 611 is rescinded and we have no protected quotes, do we still need to have the access fee caps for purposes of best bids and offers? I don't know if maybe, Brett, would you like to kind of start us off with the conversation today?
Sure. Thank you very much. I will also say I don't make any money from transactions from anybody. So just to set that straight. So look, at this point, it's very clear that if you rescind 611 order protection rule, it's going to have an impact across a number of other rules. And the more rules that it touches, the bigger these changes are going to be, and the more implications there are, and the more intense the economic analysis and all the effects across the industry are going to be have to be dealt with. I believe that as we look at this, we should not actually eliminate the access fee cap. And I'm going to tell you a few of the reasons why I think we should not, even though I do believe that we can remove Rule 611. The reasons are, number one, we have a best execution rule. And even though that's going to be reviewed and reevaluated, best execution is going to mean that in many cases, people are still going to try to access that best price in the marketplace. So institutions, in addition to the rule, institutions are going to be asking individuals, like, are you getting the best prices? And if you're not getting the best prices, why are you not getting the best prices? So in my view, the underlying reasons for the access fee cap still exist. It is still in place. There's between best execution and between institutional demands, there still is almost a de facto protection that is going to exist there. One of the examples of that would be we don't protect depth of book, unlike the Canadian market, and effectively routers protect depth of book, and that for the purposes of best execution. So I think that's the first one. The second one, without fee caps, I believe that the NBBO will be degraded. So when you look at the reasons behind the access fee cap at the beginning, one of the reasons that was presented was because there will be price distortions in the NBBO. If you don't have a cap, we saw before Reg NMS, there were access fee caps that were coming in very high. I think Attain, Market XT, there were a few examples where some of the venues came in, they put them in very, very, very high caps to try to capture all of those limit orders in the marketplace. That degrades the NBBO. And if you degrade the NBBO, it creates a whole set of other issues. How do you, what is the NBBO that you use for best execution for Rule 605? How do we think about the NBBO? Do we need to do net pricing, which is a complexity? So there's a lot of other things that come with that. I think the third thing is complexity. It adds a substantial amount of complexity. We will talk about whether or not there should be net pricing. Net pricing is complex. Now you're going to be looking at all these other prices that are mixed into the market. It might be for very sophisticated participants, easy to put into their routers and into their systems. But I think for a lot of people, it's going to be very complex. And I'm afraid that if you're not getting the BBO orders that you see on the tape, I think that there is an issue in terms of investor confidence. And the last one is I think that there are going to be more venues, not less. So if you think about it, one of the reasons why we're doing 611 is to try to create fewer venues in the marketplace. If you take away access fee caps, if you think about the way venues are shaking out, right? When inverted venues were really popular, every exchange group had to have one, right? And it was like, we need an inverted venue, we need an inverted venue, we need an inverted venue, and that led to more markets. Now, if we do this, we could have a situation where, well, we need a 50 mil rebate market too, because somebody else has a 50 mil rebate market. If you think about it, when the access fee caps go up, all of the markets, all of the biggest liquidity centers will gravitate to that highest rebate. That is the case today. If you look at the 30 mil cap and the three biggest books, and the biggest books from each of the exchange group, they're all right there at 30 mils. They all gravitated to it because that's how they capture sort of the limit orders that help to drive the liquidity book. So I think we can deal with 611 and all of the issues with that. But I think if we add excess fee caps, we're going to open up so many other issues that it's going to be harder to get this done. It's going to result in more issues in terms of the quote, less investor confidence. And so I think it's problematic. Just one last point. I do believe that the access fee caps went too far under the amendments that were put through under Gary Gensler. So I don't think that the 30 mil cap should be applied to the securities that do not go to the half-cent tick. I think we should leave that alone and leave that where it is. And there might even be some space for illiquid stocks where the cap could be higher or even removed on really illiquid names. But I think at the top of the book, I think we need to keep it. So thank you very much.
I'm happy to take the other side of almost all that to start. I think if you eliminate the trade through protection, the justification for a fee cap goes away. When you read the original adopting release, the cap is very closely tied to trade through protection and being able to access a quote because it's protected. I think all those things are valid concerns that you raise, things like Best X and the NBBO. But I don't think I'm not a lawyer, I guess would be the caveat I'll offer, but that does not seem nearly sufficient to impose, a government set price that's going to be with us for years or decades based on those items without the OPR protection attached to it. You mentioned net pricing and complexity. I'll agree there is complexity to that, but I think that also solves a lot of these issues that you raised. I think you can do, and you call it net pricing, I would maybe call it free trade fee transparency. But if an exchange is publishing a quote, I think it's very logical to say that exchange should tell you how much it costs to access that quote. We really don't do that today. We offer the quote and then we send you a bill at the end of the month for whatever the access fee was. I think we're very capable of putting on a fee, in the data feed. So the world has transparency to how much it costs to access that quote. And that I think addresses some of the risks of people, raising access fees dramatically. I absolutely agree that is a risk. Someone will certainly put in, a penny access fee and a 99 mil rebate if there's no other governor on that. But I think the best governor would be transparency and then let the market sort of evolve to where it needs to go. I agree. We're definitely at 30 mils as sort of the volume weighted access fee is right around 30 mils right now from exchanges. And it's not really clear if that's like a market based reason or it's because that's where this rule has been for so long. I think if you had something that was a little more dynamic, you'd let the market sort of decide where those fees evolve to. And if they have to evolve higher but results in better prices, that could be good. I think you would want to ultimately include, do net pricing as you call it, where you include the exchange fees in the ultimate settlement price. And I think that helps resolve a lot of issues around order routing concerns. But I think, generally, if you lose the OPR rule, I don't really see how you can justify the fee cap as it stands today.
So one point that I'd like to sort of add to what Kevin, Brett makes the point that we don't want to go into a situation where we have a penny access fee with a 99 mil rebate. Today, the commission has the power to review any exchange fee filing and really sort of rescind that any sort of approval that's effective upon filing. I mean, we've seen that recently. IEX put out a fee filing with a step-up tier without an expiration date. They had to go back to the commission, went back to them and made them put an expiration date on there. Step-up tiers were ubiquitous throughout the equity markets and, with very long-dated expirations, look-back periods. And the commission, basically through that authority, has eliminated any sort of step-up tier without an expiration date. And so it is our feeling that if a exchange came in and said, hey, we're going to do a penny access fee cap, that the staff would push back very hard without sufficient justification of what is the need for this access fee cap that's so egregious to what the market is currently at, that I think we would rarely see the extreme example that Brett pointed out.
Well, if I am sort of itching to get in here, Brett, I'm going to side with Brett on this one. He stole a fair amount of my thunder, but just to for a kind of put a finer point on some of the points that he made, it's important to remember that even at the time that NMS was adopted and more recently when the NMS amendments were adopted, that the Commission's rationale for having the access fee cap depended pretty heavily on this concern about not distorting display prices, and in particular, the best prices that go into forming the NBBO. And even during the legal challenge to those rules that was advanced by some exchanges and which were the SEC's action was sustained in court, the it seemed everybody acknowledged the point that you do not want to have an access fee in an amount that is larger than half of the spread size or minimum spread, because at that point you necessarily have really discordant prices, confused prices, and that was something that you needed to avoid. The court itself, in its decision, kind of endorsed that reasoning to point out that the existence of the cap helps to ensure a security's displayed price does not stray too far from its true price. That was the language that the court used. So all of that rationale, it seems to me, fully applies regardless of what other regulatory reforms the commission might undertake. And in particular, as Brett said, in terms of maintaining the integrity of the NBBO that market participants so heavily rely upon, it's critical that there is some limit. Now, where the cap should be set is a different question, and that's something that could be reexamined. Perhaps experience with the NMS amendments could be gained in sort of determining whether that should be where the cap should be set should be reexamined. But the rule continues to perform an important public service that I think should be retained.
So I'll jump in real quick. It's going to pain me to say this, but I agree with Brett and John on this one.
Why pain?
Well, I think if you look at the removal of 611 and kind of look back 20 years ago, access fee caps were placed, obviously, because 611 was being introduced. And so if you remove 611, the easy answer would be to say, well, we can remove access fee caps. But I think the real reason we can't is because of best execution. And by that, I mean, I can go to, if you remove OPR, I can go to a principles-based approach to best execution as an institution, and I could ignore certain prices in the marketplace at certain exchanges, but others can't. So if you look at what self-directed individuals do, they're still going to be driven by best price. And if best price is at a venue that now is, not limited or restricted for what they can charge to access that quote, it becomes challenging for those that are directing that self-directed flow. Now, if you use a net pricing model, potentially, again, it's complex, but if someone were to charge a full penny to access that quote, and you showed that then obviously being a penny worse because of the full cost of access, maybe you could do that. And someone could ignore that price and say, that's not best price technically, I have a better price somewhere else. But it gets very, very complex very quickly. I mean, this is a slippery slope. So now you're looking at inverted markets and saying that inverted market may have the best price, but is it the best price necessarily when it comes to what happens to the quote right after you access that inverted quote? How much information leakage is there for that urgency of getting that? And are you doing it because you're trying to jump the queue, which is what we do now when we go to inverted markets? Or are you doing that because technically it's the best price now with the net pricing model? So it leads to a lot more conflicts potentially that could exist in our marketplace from a routing perspective, and it's not clean, unfortunately. And again, from an institutional perspective, we can handle it, we can manage it, and we have a lot of resources that can kind of measure where we should be and shouldn't be going. I worry that a lot of other market participants can't do that. So it leads to a lot more, investor concern than there should be. That's the first thing. Second thing, as far as caps go, so we have long argued that there is a one-size-fits-all approach to a lot of regulation. For the last 15 years, we've been trying to get access fees down because 30 was a price that was set long ago. Everything else in our industry has compressed, not access fees. But again, I don't believe that it should be lower for all securities. It should be lower for very liquid securities that don't need intermediation and don't need that rebate in order to drive volume. But for less traded instruments, Brett might be right. Maybe we do increase it. Maybe the cap should be higher so that we can promote displayed liquidity. So I'm not in favor necessarily of a 10 mil across the board cut. I certainly don't want to keep caps at 30 because we've argued a long time that they should be down and lower. I think we should look at it more holistically and especially with tick size changes that are upcoming. So if you're going to narrow the tick increment, then obviously you should commensurately reduce the access fee as well. I think we need to look at that more closely, because I think the number of securities whose ticks were going to be narrowed was too broad, in my opinion. I think we should look at that, identify securities where there is ample liquidity and there's competition at the quote, figure out those securities in particular, narrow the quote, narrow the access fee, and see where that takes us.
So one of the things that when you talk about that access fees are necessary, but maybe for some securities that, maybe, we should adjust them. It sounds like we're adding additional complexity, which we could get rid of if we just eliminate the access fee cap. To Kevin's point, if we were to add the access fee to the data feed, the commission has sort of moved in that direction with fee transparency at the time of execution, which goes in this February. So in a case where everybody knows their fee at the time of execution, access fees are included in the price feed, why would we add additional complexity to it where if there's no access fee cap, the market will settle where the market settles? And if somebody wants to put in a penny access fee cap, and that quote will always be sort of at the bottom of any sort of queue, and any best X sort of measures can come into play in terms of determination of if a broker feels that it's in their client's best interest to access that quote. But it does feel like that if you add the access fee to the quote with fee transparency at the time of execution, that you get rid of a lot of the added complexity that this panel is sort of adding when you think about illiquid securities or other types of security outside of the top 50 names that trade most of the volume.
I would just also on John's point on spread, I thought it was a good point that fees and spread are obviously connected. Made a similar point. I also think what I think we want to drive to would be a more dynamic situation where we're not having this debate every few years of it should be 10 mil access fee cap for some stocks and 50 for others and 30 for that's a really challenging debate to be in. And I think finding a more market-based solution is something we should be striving for. And I think, yes, there are going to be some complexity trade-offs. I think, to Mett's point, obviously every market has different impact, or every single venue has a different resulting market impact when you route an order there. I think if you're routing a large complex order, that's, something a broker needs to optimize for. But again, I think that's something that the people deal with today. We would be dealing with in a different way with a different model like this, but I think it's manageable.
Well, on the later panels, they're going to have some real challenges with how we look at the MBBO and how it affects 605 and limit up, limit down, and short sale rule 201, et cetera. If you don't have a fee cap, it really does have a distortive effect on the quote. That adds a lot of complexity, and it's going to mean we're going to have a lot more, in my view, a lot more locked and cross markets as well, because then what is the BBO? If you have super high things, it gives you a rationale with no 611. I'm not going to hit that quote because that guy's charging way too much, or it might be, now I have to link to a market just to try to deal with that particular quote because it's very high and a lot of liquidity providers have gravitated there. So if we have a maker-taker world, and we have a best execution standard, the fundamental reason behind the access fee cap is still there. It hasn't changed. OPR might not be there, but the fundamental reason we did it in the first place, all of those forces sort of still exist. And if we take that away, we really are going to, it's going to make this rulemaking you're going to open up so many other.
Sorry, I would just add, I don't want to exhaust the topic before and let Kelly move on, but I would say that I think having a cap, I think by itself does not necessarily add new complexity. I think in some sense it avoids the complexity that you would then that could incur by having the market distortions that you worry about. Again, I think the question of where you set the cap is a different question. I think it can be set at a level where there is still plenty of opportunity for exchanges to compete and set, in terms of both fees and rebates in a way that, involves healthy competition. But I don't think having a cap is going to create any complexity that people won't be prepared for.
I was going to start by saying that I agree with Brett, not because I always agree with Brett. I tend to agree with him pretty often, but I started my career as a software developer, as a quant. And there is a concept in software development known as test-driven development. The idea is that you first write a test before you start either creating a new system or significantly modifying a complex existing system. And I think this concept is very relevant to what we're trying to do. I think before we go into the details of exact level at which fee cap should be set or fully removed, we need to establish the criteria of success and failure. I think we need to establish the metrics by which we can evaluate them. And to me, the ideal outcome of NMS reform, if I may, is the following. I think as Commissioner Pierce said, and as is often mentioned in all panels, U.S. markets are the envy of the world. We need to make sure that the experience for retail investors is not degraded. We need to make sure that the experience for institutional investors remains at least or hopefully better than it is today, meaning their ability to move large blocks of stock. We want to foster innovation, and we want to make sure that all the ills or issues associated with Rule 611 are mitigated or resolved, such as high cost of connectivity, proliferation of exchanges, and overall market complexity. So to that end, I would say that philosophically, I think I kind of see Kevin's point that the reason we have cap in the market today is because of the OPR, and markets in theory should figure it out. But I think a big elephant in the room is best X. If we're moving towards, and I know it's going to be covered by a third panel, but if we're moving to principle-based best X, it's unclear to me to what extent brokers will be held liable to giving the best available price to a client, no matter what the execution fee is. Without knowing that, it's very hard to figure out the direction for fee cap, because we know, as all previous panelists said, there will be market distortions. There will be market centers that will come up with exorbitant excess fees. And I think, again, to agree with what John and Matt and Brett said, I think in order to mitigate that risk, we need to keep the cap in place. There are a couple of directions in which the Commission may go with the level at which the cap should be set. Option number one is status quo. Keep it at 30, minimize the variables that are being changed, measure the results, evaluate the effect of just abolishing 611, and potentially implement the change later. Option number two, proceed with the decrease of a fee cap to 10 mils across the board. Option number three, as suggested by Matt and Brett, is make it more nuanced, meaning lower it for some names, keep it at 30 for some other names, and potentially increasing them for the rest of the universe. There is another option. You can say, let's effectively remove the fee cap, but let's create a guardrail at, for example, half a tick. So if a tick is a penny, make it 50 mils. If a tick is half a penny, make it 25 mils. That would effectively preclude a synthetic cross of the quote, and we'll talk about lock and cross later on. But this is one of the potential options that I think should be reviewed.
John, should I have a question?
No.
Okay, thank you. It's been a good start. Maybe we should throw a little bit more complexity in. What if one of the scenarios was to modify 611, like putting in a market share percentage. And so then you would have some markets that are protected and some markets that would not be protected. Does that change anyone's analysis on what we do with the access fee caps? Do you keep them? Do you only keep them for those markets that are protected, but not the ones that are not? Anyone have any thoughts on that?
I'll start by saying it doesn't change my analysis, because I think that the access to the best prices at each market are still, you still have the concern about price distortions. And to put it this way, I think all of those quotes that go into forming the NBBO need to have some kind of access cap related to them. So it may, that raises the question of how it is the commission preserves the integrity of the NBBO. So you know exactly which quotes you're are forming that price measure. But because that price measure is so critical for bunches of purposes, some of which have been touched on and others that haven't, I think it's really important to regardless of the form that the reform takes.
I would second that. I generally agree with what John just said. I think the key issue is I don't think these things are as linked as people think they are anymore, right? It's not just, oh, we have an order protection rule and therefore you have to have an access fee cap. Again, with best execution, with institutional demands, with the expectations of retail investors, the forces are still in place to be wanting to take out the top of book. So I don't really think that's it. That was a reason why they put it in. It was not the reason or the sole reason. The price distortion issue was also very much the case. But I do believe, as I mentioned before, that we did go a little bit too far in the last proposal, and I don't see why we had to bring them down for the stocks that did when they went to 0.5 cent.
I think if you do, I don't disagree that if you have two sets of rules there for both protected and unprotected, like I think you're adding more complexity. I really like Dimitri's point before on keying the access, any sort of cap or anything off of the tick size. And, I think that's a really good idea and concept. It's also going to add a lot of complexity. So I think, one way or another, I think we're gonna have to figure out how to deal with some of this complexity. And if you want more nuanced approach, like a volume-based threshold with slightly different rules for, exchanges above and below a threshold, I think you're going to very quickly get into a world where you have to have some sort of more, data sharing or transparency or something. Like I think we're going to have to figure out how to approach this complexity, because it sounds like a lot of these ideas, one way or another, do introduce more complexity to the market.
If I can real quick, I've never been a big fan of modification Rule 611. I think, if we're going to amend 611 to make it work properly, I think we should just repeal it. It's a cleaner way of approaching it, and it kind of gets to the point of where we're trying to accomplish. And obviously there'll be amendments to other rules that need to be made, but creating a market where there's a threshold or a block exemption, or lifting the prohibition on locked and crossed just to make something work because it's not working the way it was intended doesn't make sense to me, because I think we're going to be in that continuous amendment type of engagement there, where we're constantly making exemptions to a rule to try and make it fit what we're trying to fit. So the way I look at it, my comments are for repeal. My comments wouldn't change much for reform, but I think reform's a bad way of approaching this. And I think the folks that want to reform look at it as a good first step into trying to repeal and seeing what that might lead to. But I think it'll lead to a lot of unintended consequences when we reform something, and the market may change, not necessarily for the better. It'll certainly make things a lot more complicated. But I think we'll be in my opinion, a worse state than we're in currently. So either leave it the way it is or repeal it.
I have to say that I totally agree with Matt. There is an argument that the Canada-like solution of only protecting markets that exceed a certain threshold would solve one of the perceived ills of 611, which is the uncontrolled proliferation of exchanges. I think there are easier ways to do it, such as the reform of the SIP formula, revenue sharing formula. I think the solution that would require exchanges to have certain threshold is fraught with a lot of complexity and issues. I think it's going to create a two-tiered market. I think it's not going to solve the issue of brokers that are already connected to those exchanges, because the volumes can fluctuate, right? So it doesn't make sense for a broker to disconnect from an exchange if it falls below the threshold, only to have to connect to them again in a few months. I think it's going to add more complexity and not going to solve any issues.
I hate to say it, but I also agree with Matt on this one. But the only other thing I would say is that I'm not sure, though, my views on 611 if it comes with an excess fee cap, because I feel like those issues are substantial enough. So if they're separated, I think it makes complete sense to do it wholly.
Sort of our feelings, if there's a threshold model, that again, there's no need for an access fee cap. I think one of the things that we feel is that simplicity and straightforwardness should rule the day. I don't think anyone wants us to get to a state where we make changes and then we have NMS like FAQs that are coming out. I remember when Brett and I were at Bear Stearns during the start of NMS, Brett was working furiously with SIFMA to try and get as many exemptions to NMS as possible so the institutional desk could do what it wanted to do. So we don't want to be in a state where we make changes and then all we just do is sort of work around it through very complex FAQs.
It was clarification. It was clarifications, and there were some areas, honestly, where the rule needed to have exceptions, and we had to negotiate those. No doubt.
I would just add,
Sorry, let's move on to lockstep prohibitions.
Well, I hope the next conversation is just as lively and informative. This has been really great. So the other provision we wanted to talk about in 610 is the lock cross market prohibitions. So the commission adopted these prohibitions to address the technology that was occurring, it's kind of building up at that time, but also to address potential investor confusion if the investor was going to see a bid and offer either matching or crossed. And so in the 20 years since we've had Reg NMS operating and the technology that is, built up and is so much different, do we still need lock cross prohibitions? And I guess I'd also add, as you guys are thinking about your responses, do we need locked prohibitions or not? Or do we need cross prohibitions or not? Should we think of them separately or think of them together? So who wants to jump in and start us off?
I'm happy to just say that. So I think that it makes sense to like if you think about what is the basis for the rule, and if the basis for the rule is to maybe make it so it's less expensive, you don't have to connect to all the venues. Maybe there's some very, very small venues that aren't adding a lot of value. You don't want to connect. If the locked and cross market prohibition is still there, then argumentatively you would remove that benefit from the rule. So generally speaking, I think with an elimination of 611, it does make sense to eliminate the locked and cross market provisions. But again, if we link in the access fee cap to that, my view is if you take away the access fee cap, honestly, you'll have so many locked and cross markets that I don't think if you do that, I would support the elimination of locked and cross, because I think that would further contribute to the degradation of the NBBO. So it's sort of these things, again, they're all linked, right? It's a very, very much of a multivariate analysis. I think even with the locked and cross market elimination, as we talk about the SIP revenue discussion, and I hope they get to this later, my view, though, is when we work out that new formula, any market that's actively locking or crossing a market for however we're doing this formula should not be receiving any SIP revenue during that. There needs to be some economic disincentive for participating in active locks and active crosses in the market. And I think that's one way of getting at that.
Yeah, I mean, I still, I guess from a market practitioner perspective, I still don't really understand why locked markets aren't allowed. If the bid is $10 and the offer is $10, I can trade at $10, whether I'm a buyer or a seller. Why wouldn't I want to do that? I mean, we complain all the time that people aren't getting as much of the spread as they would like. In that case, there is no spread. The prevailing price of something is $10. Let's trade. And so I've never understood, frankly. I know ATSs can't operate currently, or a lot of them won't cross during a locked market type of scenario. But again, it's 10 by 10. Cross me at 10. I'm okay with that. I'm very happy with that price. And guess what? There's no adverse selection post that. There's no information leakage. There's a lot of benefits that come with crossing when the market is, basically as true price discovery, so to speak. So when I separate them, I think you can remove the lock prohibition. The cross prohibition is a little bit different. One, I don't know anybody that wants to cross the market intentionally right now. I think if you did, there's a significant arbitrage opportunity that's available, and there's an efficient market that will probably, interact with that quote. I do worry about if we go to a model where there's no access fee caps and no net pricing, because then you distort what the true market is. Behind the scenes, it could look like 10 by 10 or, inverted, obviously, 10 by 9. But really, it could be the other way around because clearly there are rebates in play or something else that's, that allows someone or makes someone interested in crossing the market. Because like I said, right now, I don't know anyone that intentionally would want to cross a market. You're probably just going to lose money that way. So if we had to remove the restriction on cross markets, I think you'd have to, apply a net pricing type model. Which would, again, make it so that people weren't crossing the market intentionally. But again, that leads to a lot of complexity. But locked markets, yeah, I mean, that should go away. Regardless of what happens with 611, we should get rid of the prohibition on locked markets altogether.
Yeah, and I think, but I agree with what Matt said. I think also in terms of a locked market, even, the true all-in cost of that locked market, the market's not really locked, right? If you bids and offers at 10 cents. And we actually see this sometimes. I think a lot of locks that we see in the market are sort of transitory and maybe only on the SIP and not really in direct feeds. But we see some fixed income ETFs and products like that will be locked for significant periods of the day. But in reality, an offer of 10 cents does not mean I can buy for 10 cents. It means I can buy for 10.3 cents or whatever the access fee is. So I think that's something important to remember, even if it's locked on an all-in cost basis, it's really not locked. But I agree. I think in terms of removing 611, it seems logical to remove the lock and cross prohibition to really get the full benefit of the 611 removal.
Yeah, I agree with Matt and Kevin that the elimination of locked markets would make sense. And I also agree that, in very liquid names, there were cross-market arbitrage traders would clear out those crosses very quickly. The only concern we would have is there are a number of very illiquid symbols that could potentially be crossed that no one is paying attention to, and they sort of remain in a cross state for the whole day because those names really don't trade that much, if at all. So definitely supportive of elimination of locked markets. And in terms of the reduction of complexity. As an exchange operator, we have to create a number of order types, and we have a lot of mechanisms that we have in place with our various order types where we will price slide orders, we will hide an order if it's going to lock the market, and it would just make life a lot easier for, sort of our operation as well as sort of price transparency.
And I think functionality transparency, just to jump on that quickly, I think we would be able to get rid of a lot of the order types that lead to a lot of investor confusion or concerns that there's all these really crazy ins and outs that I don't understand what's going on in the market. A good bit of that I think would go away if the lock cross prohibition was gone.
I want to touch briefly on complexity and order types. I think if 611 is eliminated, I think everyone would probably agree that there is no need for ISOs. However, I can pretty much guarantee that there will be another slew of order types that we can't even think about today that will be specifically designed for a new structure, whether locked and crossed is allowed or partially allowed. So I'm very skeptical on reduction of complexity. I also want to say that I think we have something close to a consensus on locked. I think the only caveat for locked is we need to think whether a single market can lock its own quote. Because in theory, two add-only orders can lock a single book. And I can argue both sides whether this should or should not be allowed, but the end result of it is going to be that in many securities, markets are going to be locked pretty often. And again, going back to my point about the criteria of success, we need to understand what are the implications for the market quality, how we're going to view 605 in case of cross markets, and see whether there is any way for us to keep prohibition on cross markets.
Thank you. I have a little bit of a tangential point. I have a strong view about sort of locked versus crossed prohibitions, but I just did want to make the point that I think all of the aspects of Rule 610 in some sense are restrictions that are intended to make sure that quotations are useful, that they perform a general public benefit. And I think what some of us are saying is that, some of those restrictions need to stay in place. That doesn't mean that we Commission shouldn't do other things to incentivize more displayed liquidity. And that's a really important thing to keep in mind, that it is, people have talked about the decline in exchange trading, but the decline in percentage of lit trading that actually is a portion of the total has been even more dramatic. I think according to our figures in 2017, the lit proportion of total trading that resulted from lit trading was about 46%, down to 27% so far in 2025, and continues to be. So other jurisdictions seem to be moving in a direction of trying to do more to support display trading. It feels like in recent years we've been moving in the opposite direction, which creates real perils for our market.
So, John, do you think that the repeal of 611 would lead to the further degradation of liquidity?
I don't know. I mean, there certainly is an argument that it isn't. My only point is that I think that the Commission needs to carefully evaluate whether the full package of reforms, like taken together, because people said there's all these interactions, to have a reasonable basis for concluding that it will not further erode displayed liquidity, and will support it. And there are probably various ways to get there.
Just a quick final point on locked and crossed. So the way the rule operates is that the Commission requires exchanges to have rules that prohibit locked and crossed markets. So if the Commission eliminates that provision, the exchanges would still have those rules. Should the Commission take the further step of requiring a uniform position across the exchanges, or leave the exchanges to have their own rules with respect to that?
Well, I think if there were Commission level changes, I think we would adjust our rule book in turn. I can't foresee a world where we'd want our own displayed quote on a venue to be locked, just as a policy matter internally. I would probably say let each exchange decide how they want to handle it. If an exchange wants to maintain the policy of not locking an away quote, that's fine.
It gives the exchanges a greater ability to be more competitive for lit quotes at the inside market. And everybody wouldn't have to use day limit ISOs all the time to post at the inside, where they have to have all these data sources. So there's a lot of people who can't use that order type, and it makes it harder for them to aggressively quote at the inside, like quant funds who aren't broker dealers that need the broker dealers to manage the obligation. So I think it makes for more competitive quoting at the inside market, and it helps with exchange lit competition.
Yeah, we would prefer sort of to amend our own rules in this case.
Thank you. I think I have one last question just on lock cross, because the Commission was considered about investor confusion. If we go back to retail investors, someone who's going to be looking at a screen, is anyone up here concerned about investor confusion if the price matches or if it's crossed?
My firm doesn't serve retail investors, and I think it's very hard to measure confusion. However, I would say that I can easily imagine a rise in the number of calls for retail brokers asking questions. So it's going to take time. It's going to take some effort on behalf of retail brokers to educate their clients. The main thing that matters here, I think, is the quality of execution for retail, right? If the quote is crossed, how do we measure quality of execution for retail? How do we measure price improvement if, in the case of crossed quotes? In the case of a locked, it's very easy, right? It's clear. We need to think very hard about 605 in the context of cross quotes.
Thank you.
Yeah, I would echo that. I don't think self-directed or retail investors would be confused by a locked market. Again, it's just, it's bid at 10, offered at 10. Sounds good. If I'm a buyer or seller, it's 10. I do think cross markets could obviously lead to some investor confusion as to why someone would want to do that intentionally, or why that market's crossed in that specific case. But again, and from what Dimitri is mentioning, from a best execution perspective, the EQ stats on a locked market are 0, so it's good. the EQ stats on a cross market would be confusing for people to kind of measure.
Totally agree with that. And I think there is an outlier scenario where you could see more cross markets, which is if, for example, we have a lot of exchanges, we have a lot that have come to the table. If you had a very small exchange that showed up that had, let's say, reasonably high connectivity fees and also had a very, very high, if there were no access fee caps and had a very, very high, rebate and take rate in the market, some people might just say, well, I'm not connecting to them and I'm not taking them out. And it might be one of those scenarios where you do have a greater proliferation. I think that scenario is problematic and we would want to avoid.
Thank you. I mean, why don't we move on? I think we only have a few minutes left. And we kind of went in a order where we skipped the main two parts of the rule, where is the provisions A and B, which provide that there should be fair access within the national market system, and maybe in the 611 world, a world where the Commission is considering changes to the national market system, do those provisions remain relevant? Do we need those provisions to ensure that there is fair access in the national market system? I don't know, John, do you want to start us off?
Yes, easy question for me. I think they absolutely remain relevant. I think the purpose of 610A is independent of, in some sense, of all the others. For one thing, it applies not just to protected quotes, but each quote, including each display quote, including reserve size. And really the point is to be able to say that exchanges can't, for example, give preference to orders that are submitted by their own members over other orders. You can imagine all kinds of practices that could result from that would be problematic. So it's important that the Commission supports the reasonable, fair access to quotations, regardless of what happens to any of the other reform. And I would just say, I think the existence of that provision has also allowed the use of private linkages rather than a mandated kind of linkage, like the old ITS, for example, and has allowed both direct and indirect access to exchange quotes, which has been a system that has worked fairly well.
Yeah, I would just add from an investor perspective, I think displayed quotes need to be accessible. So having unfair access to quotes, displayed quotes would be problematic because, again, when we're going into the market to interact with a displayed quote, my intention is to interact with that displayed quote. It is not to be told later that there was segmentation there was preferential treatment for one quote over another, and therefore you couldn't access that quote. Now, again, I'm not a fan of thresholds, but if you said that you were going to use a threshold model so that venues above a certain threshold would contribute to the SIP and the NBBO, and those were accessible quotes, and they still had to abide by fair access, whereas venues below a certain threshold weren't part of the NBBO, weren't part of the SIP, and therefore didn't have to have fair access provisions to them. That I could understand. Because again, then those quotes aren't displayed and need to be accessed necessarily. They can be potentially displayed, but you can ignore them. And my intent when I go to interact with it would be different.
I think it's important to note that there has been really great and extensive innovation in the off-exchange landscape and ATSs. We have all sorts of counterparty selection in place. We have private rooms. We have a lot of activities. And now we have over 50% of the market share is off-exchange. And so I do believe that in eliminating Rule 611 potentially is sort of taking away from some of the power of the protected quote or power of the lit and displayed quote at stock exchanges. And so I think there's a really important question here, which is how can exchanges continue to compete with all of the innovation that's happening in the off-exchange marketplace? I don't know exactly what the solution is. I feel like there should be more flexibility for them to compete against these other trends. The value of a retail quote is different than the value of an institutional quote, is different than the value of a stat arb quote. And the market has recognized this in the off-exchange landscape. And again, I think this may be like a request for information or some sort of request to really get people to dig into this issue because it's complicated, but it's an important one. And there needs to be some leveling, I think, for these guys.
Yeah, I sort of agree. Sort of all displayed quotes should always be subject to fair access. Anything that is driving the MBBO should be accessible to anybody and everybody. The area that I think that exchanges would like a little bit more flexibility, or at least CBO would, is around the non-displayed area. Let us innovate in certain products where we might be able to create ATS-like functionality due to either segmentation or different type of market models where we are allowed to create bespoke outcomes like ATSs can, only in the non-displayed space. We already have retail price improvement programs across many exchanges, which is some form of that type of segmentation to benefit retail specifically, but that is excluding sort of a broad institutional-based customers that we are not able to compete with, and have pretty much ceded all of that landscape to ATSs.
I would agree with Oliver with one caveat. If exchanges are given flexibility to segment subscribers in the dark, those subscribers should not be given preferential access to displayed quote.
Agreed.
Yeah, I want to be able to say I agree with Oliver on something, so I do agree with you on that. I would just add that I think the commission should provide more flexibility in various ways for exchanges to innovate in both displayed and non-displayed trading, and I think there are various ways that can happen.
I think we're almost at time.
We have a minute or two. So just to round up in terms of the implementation of any changes, any thoughts on whether it should be a big bang, slow rollout, sequencing of rule changes? Some general thoughts on that as we close out.
I think in terms of whatever changes are made, whether they should be gradually applied to some segment to the market first or to the entire market, my preference would be for a big bang. I think it's going to be very hard for the market to kind of comply with two regimes simultaneously. In terms of the sequence of changes, again, as I think I said before, my preference would be for some sort of a cap to be preserved, for the locked market prohibition to be rescinded with some caveats on the single book, and for cross markets to be still prohibited. The effect of the change needs to be measured over time, and potentially, who knows, maybe a couple of years down the road, we'll go to the full free market solution. But I think that would be a very reasonable and relatively safe and potential improvement over what we have today.
I think you should also just find I think a segmented rollout would be helpful. I think we also just need to factor in the other changes that are currently scheduled, for example, in November. There's a lot of moving pieces right now, and I think thinking about all of it and kind of doing it in a way that makes sense, even if something gets passed second, goes in first because it makes more sense in terms of moving up to this new world, I think would be helpful.
Well, these things are all linked. They're not necessarily linked in the implementation, right? So right now, it's very hard to answer the question because we've talked about 5 or 6 different things, and we don't actually know what the final package is going to be. And that final package will be very instrumental in terms of how we think about this. In my view, eliminating 611 is going to take some time to get through a common process and potentially work through that. There's other things that can happen in the interim, right? So the access fee cap changes that are coming, I don't think there's any reason to further delay that rollout, but I do believe that in this process, it is possible to tweak and change that, right? So you may decide upon further review that you don't need to, as I mentioned earlier, at a minimum, you don't need to take the 30 mil fee cap down for the stocks that didn't go to a half a mil. The SIP revenue allocation formula, this is very important, and this is connected to all this, but they should be doing this already. In my view, this should have been done, about 2 years ago, right? So the SIP revenue allocation formula is broken. It needs to be updated, and there's nothing that's stopping that moving ahead right now. Fair access is a bigger issue, and I think it's going to require some more debate, and we'll see to what extent that actually links into all of this. That'll be great to watch. And again, I know another issue you guys are talking about is the vendor display rule, and I think that's another one that you need to look at. How that fits in ultimately, though, in terms of sequencing, will depend on what these final rules turn out to be.
This has been a great conversation. I thank you all for coming down to Texas and joining us today. And please, comment files open. So if you guys have more you'd like to tell us, we would always accept comment letters.
So we're going to take a short break until 10:45. So please join us in thanking the panelists.